hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with
Welcome back to the next episode of the BC Law's Just Law podcast. I'm Tom Blakely. I'm here with Samantha Beyar. We're joined by Professor Ryan Williams to talk about a topic that is as important as is polarizing. That's obviously what's gone on recently with the Supreme Court and abortion and the Dobbs case. We're joined by Professor Ryan Williams, who's going to discuss the case with us today. Professor Williams joined the BC Law faculty as an assistant professor of law in 2016. He teaches and writes in the areas of constitutional law, civil procedure, and federal courts. His research has included works focusing on the original meanings of the 5th, 9th, and 14th Amendments, as well as works exploring the intersection of constitutional rules in the civil litigation process. His prior publications have appeared or are forthcoming in the Yale Law Journal, Columbia Law Review, Stanford Law Review, the Notre Dame Law Review, and the Virginia Law Review. After graduating from Columbia Law School, Williams worked as a litigation associate in the New York office of Sullivan and Cromwell, where his practice focused primarily on class actions and other complex commercial litigation. After leaving practice, he was a Sharswood Fellow at the University of Pennsylvania Law School from 2011 to 2013, and an associate in law at Columbia during the period of 2013-2016. And he's here with us today. We're very happy to have you on, Professor Williams. How are you?
Very good, thank you. Thank you for having me.
Sure. Well, we want to get into the case and kind of talk about what's happened here. But before talking about the Dobbs decision itself, we wanted to just back up a little bit and sort of talk about how the Supreme Court got to this point. So there's an article in the New York Times on June 25th by Charlie Savage, and it starts off saying, in the spring of 1985, a 35-year-old lawyer in the Justice Department, Samuel Alito Jr., cautioned the Reagan administration against mounting a frontal assault on Roe versus Wade, obviously the case we're all familiar with, the landmark ruling that declared a constitutional right to abortion. The Supreme Court was not ready to overturn it, he said, so urging it to do so could backfire. In a memo offering advice on two pending cases that challenged state laws regulating abortion, Mr. Alito advocated at the time focusing on a more incremental argument. The court should uphold the regulations as reasonable. That strategy would, quote, advance the goals of bringing about the eventual overruling of Roe versus Wade, and in the meantime, mitigating its effects. More than 3 decades later, Justice Alito has fulfilled that vision. Professor Williams, if you could just sort of talk to us a little bit, and feel free to tell the audience anything about yourself that you'd like, but just in the decades since Roe, how did the Supreme Court get from there to here, and what's happened during that time?
Sure, thank you so much. That's an interesting observation about now Justice Alito. I had not seen that article and not sort of heard that discussion, but it is an interesting kind of insight and window to the thinking at that time, because it kind of plays into some of the developments that happen in the road between Roe and our present circumstance with Dobbs. And let me go back to sort of Roe itself, which is decided, of course, in 1973. This case is decided by a 7-2 vote of the Supreme Court, written by an appointee of Republican President Richard Nixon. Other Republican-appointed justices join in the majority. The two dissenters were William Rehnquist and Byron White, one appointed by President Nixon, one appointed by former Democratic President John F. Kennedy. And at the time Roe is decided, it is part of an outgrowth of a line of jurisprudence that is kind of burgeoning in the courts, really stemming in a significant way from the 1965 decision in Griswold versus Connecticut, which recognizes a constitutional right of married couples to use contraceptives in their own home. I get that kind of, and subsequent decisions sort of decided in the interim. I just give that kind of as a background, just to kind of set the stage, because at the time Roe is decided, it is not the political football or the contentious issue it is today. Now, there is obviously very strong feeling on the issue and a lot of division within the states and in the federal government about how to proceed in this area. But it is not politically polarized in the way it is now. It was common to see pro-life Democrats and pro-choice Republicans and vice versa. That begins to change over the course of the 1970s, really crystallizing with the election of Ronald Reagan in 1980, where the Republican Party organizes very centrally around opposition to Roe and support for abortion restrictions, and the Democratic Party gravitates more towards the opposite direction. Now, I give that background because I think it sort of informs what someone like Mr. Alito is thinking in the mid-1980s in terms of the overall policy goal of a president like Ronald Reagan, which is to undermine Roe in some ways, or find a way to narrow or lessen its significance, and trying to think of the tactical ways to do so. Now, the sort of ironic thing that I just hearing that description is that the Supreme Court kind of goes in a direction that Mr. Alito suggests in 1992, the Planned Parenthood versus Casey decision, which did involve actually a frontal challenge to the Roe decision itself. By this time, it is after the presidencies of Ronald Reagan and George H.W. Bush, both of whom ran on very strong kind of pro-life platforms. And at the time of the Casey decision, a majority of the court is actually appointed by justices who've run on a pro-life message. There's only one remaining Democratic-appointed president on the court at that time, and it is Byron White, one of the dissenters in Roe versus Wade. Now, a lot of people thought, given that background, given that context, Casey might be the occasion where the court would overrule Roe. Instead, they took much more of a kind of intermediate measure, somewhat along the lines of what Mr. Alito is suggesting in that article you're describing, where they replaced the very rigid trimester framework that had been suggested by Roe with a more flexible undue burden standard, but they refused to reverse what they call the core holding of Roe, including the absolute prohibition on any laws that criminalize abortion prior to the point of fetal viability. Now, in the aftermath of Casey, of course, this controversy doesn't go away. The parties don't realign themselves in any significant way, and the Republican Party continues to press for ways to narrow and avoid and get around the restrictions of Roe. Now, in the aftermath of that decision, it becomes much more clear that a frontal assault is not going to work. Much of the action moves toward the states. And the action in the states involves largely working within this undue burden framework to try to find ways to lessen and limit access to abortion within the parameters specified by the Casey decision. And really, that has been the terrain of abortion litigation over the past 30 years since the Casey decision. And really, Dobbs arrives at the court in this posture in somewhat kind of unusual circumstances, because really Dobbs was teed up as a case kind of pursuing that strategy, sort of seeing what are the outer limits of Casey. Particularly the law at issue is a 15-week abortion ban prior to the point of viability, but the argument by behalf of the state of Mississippi is that maybe there's a way to reconcile this with Casey by sort of changing how we think about that undue burden standard without sort of making a frontal assault. During the course of argument and briefing, that strategy changes, and both sides kind of take the position that if this law is going to be struck down, it's going to involve a frontal assault on Roe. And that is kind of where the case kind of winds up in the ultimate decisional posture.
Thank you. That was really insightful. I was lucky enough to be a student in your common law class in the spring, so I'm especially excited to hear everything. And I wanted to start off talking about the leak. You wrote a great article for NBC in May that discussed the fundamental problems with the actual leak itself, not the opinion that was leaked, but just that it was leaked, the draft. And Chief Justice Roberts has called the leak absolutely appalling. And I wanted to know, just explain shortly why you think the leak was so remarkable and why it's so problematic.
Yeah, this is a new feature of this case that we haven't kind of seen in this form, at least in the court's modern history. If you go back to the 19th century, you can find some precedents of some somewhat similar context, sort of draft opinions of, for example, the Dred Scott decision kind of made their way into certain newspapers prior to the time of that decision, but it was not the media environment that was today. So if you didn't subscribe to that newspaper, you wouldn't probably hear about it. Since that time, particularly in the 20th century, the court's gotten much better in terms of keeping its secrets and keeping its confidences. Opinions will, or information about voting alignments or opinions might leak out here and there. Something similar happened in Roe, for example, very shortly before the opinion. But an actual opinion itself leaking, the full draft opinion, is something we really haven't seen in the modern era. And it really did kind of cast some, I would say, some uncertainty and some doubts within the court from all sort of outside reporting that we can kind of discern and sort of discussing and conversing with people who've kind of worked in that institution and have had that experience of working within the court, it does very much rely on the maintenance of confidences to kind of ensure the free flow and exchange of ideas and information within the building. The exchange of drafts is a very central way that the justices kind of negotiate and come to agreements about what to include in opinion, what to leave out, and the ability to share that information with those within the justice's circle of confidence, clerks, court personnel, etc., really facilitates that exchange of information. So the disclosure of this draft opinion really was very much unprecedented in the modern era, and I think there is some valid concern within the court and among court watchers about what are the implications going forward? Is this going to be a routine feature in the future? Is it going to work more like Congress or the presidency or executive departments where leaks are just sort of an ordinary part of doing business? If that becomes the norm, I think it's going to lead to some very profound changes regarding the internal dynamics of how the court interacts internally as an institution. Now, that could be a good thing, it could be a bad thing, but it's going to definitely be a change in the way the court operates.
So to follow up on that, Professor, so obviously, you know, as you mentioned, a leak from the Supreme Court of this nature is you know, would seem is unprecedented in the modern history of the court. But obviously, dealing with controversial topics and making controversial decisions is not something that's new to the Supreme Court when it comes to dealing with cases that involve obviously very polarizing issues throughout the country. And obviously this involves a deal of speculation, but what could it be about this decision in this court that might have caused the leak to happen today? Because this is probably not the first time that this could have happened, but it certainly is the first time that it has. So is there something about the court? Is there something about the moment, this moment in history and in the country you could point to? Like why did this happen now?
It's a great question. I think we won't really know for certain until we know more details about the leak, including probably who actually leaked the document, which is something we may or may not discover, or may discover sort of many, many years later. The motivation, it's always possible to speculate about what the motivation could be, but without kind of knowing the actual details, it's hard to kind of point to a direct causal effect. Now, obviously, this is a very significant, highly salient case. It's probably the most controversial decision the court has handed down in at least a decade, probably. You could go back to NFIB versus Sebelius, a healthcare case, maybe kind of a possible example. I'm not even sure that would compare in quite the same way. You could make a case. It's probably the most controversial case the court has had since the Casey case in 1992. So obviously the stakes are incredibly high. The public interest in the case is extremely significant. So that probably contributed in whatever way to the motivation to leak. Now, I don't think there's anything that has changed in a meaningful way regarding technology or other things. I mean, there are obviously greater sort of copying and other sort of technological tools available now that can kind of facilitate these sorts of things. But I think from what people have sort of gleaned from looking at the document, it looks like this was originally a paper document. You can see the staple marks and other things. So it's the kind of leak that could have happened certainly in a much earlier era as well.
Right. And do you think the court is more likely, in your opinion, to go more towards transparency or being even more locked down? And what do you think is the benefit of each of those options?
Yeah, so this is an idea I sort of floated in the NBC article, and it's not unique to me. Other people have proposed this in the past, that maybe we should think about are there ways to be more transparent in terms of the judicial decision-making and opinion writing process? Some have argued, for example, that it would be beneficial for the justices to share drafts of their opinions with the public, allow for a period of kind of public notice and comment similar to what we have for administrative regulations and other sort of important modes of rulemaking, to give individuals a chance to opine before the thing be opinion becomes final. Now, I thought this was kind of potentially an interesting test case of that proposal to see kind of we have a draft available in the public, see what changes there might be. Now, those who've gone back and looked at it, that was sort of certainly my immediate impression, subsequently confirmed by those who've sort of taken close kind of red line and other looks at it, is a very, very little change from the draft to the final version. So all the public commentary and discussion regarding the contents of the opinion were sort of not in any way sort of meaningfully incorporated into the draft. The draft apparently was sort of pretty final at the time it came to the public's attention, and very little change thereafter. Now, you could imagine a court that would be more receptive to that kind of proposal, but if the court is not really interested in sort of having that kind of outside input, I would expect that the transparency mode will probably be a less preferred option than sort of trying to go back to the way things have kind of always been done in the modern era.
So, Professor, now turning our attention to the decision itself, can you talk a little bit about what this decision does, what it does not do, and specifically how it does it? What was the majority arguing here?
Sure. So the question kind of, the case tees up kind of, well, as it eventually is disposed of by the court, it tees up kind of two central questions. One is the question of the correctness of the Roe decision itself, the initial decision to extend heightened constitutional protection to abortion rights under the framework of substantive due process. And then the second question is, regardless of the correctness or incorrectness of the original decision, should we stand by it as a matter of stare decisis? Now, the majority opinion kind of answers both of those questions in the negative. Says Roe was not correct the day it was decided, does not comport with the majority's what the majority believes is the correct approach for identifying fundamental rights that should be singled out for heightened scrutiny. The majority says the correct approach for addressing this question is to focus on rights that are deeply rooted in history and tradition, drawing on an important strand of earlier substantive due process cases where the court has employed that test and framework. It concedes that framework is not has not always been used by the court. There's certain important precedents, including Roe itself, as well as the Griswold case recognizing a fundamental right to contraceptive use, as well as Lawrence versus Texas, which recognized a fundamental right to certain forms of sexual intimacy, as well as Obergefell versus Hodges, which extended constitutional protection to the right to marry someone of the same sex. Depart from that framework, don't work within that deeply rooted in history and tradition test, but the court says that those issues, those other rights, are not directly implicated here because none of them involves the unique context of abortion, which implicates the potential effect on a human life or a potential human life. So finds all of those other decisions distinguishable, says this case is narrowly focused on the abortion issue. On the stare decisis question, the majority proposes a somewhat new framework. The Casey decision, as most 1L common law students learn, deployed a pretty elaborate stare decisis framework focusing on a number of factors, including reliance interests, workability, and whether there have been important changes in facts, circumstances, or doctrine. The new framework that's announced in the Dobbs decision incorporates some of those considerations, including reliance and workability, but dispenses with that inquiry into whether there have been significant changes in facts or understandings of facts, and replaces them with some other considerations, including how egregious was the initial error and how the quality of the reasoning reflected in the original decision. Now, applying that new framework, the majority concludes that the balance of considerations tilt in favor of overruling the Roe decision because, among other things, they believe the initial decision was egregiously wrong. They believe the undue burden standard announced in Casey has proven unworkable, and they discount the reliance interest at stake, suggesting that there are not tangible, concrete reliance interests that are implicated here, more general amorphous societal interests. And with regard to those, the court kind of suggests, the majority suggests, that is beyond the judicial competence to measure and does not provide a strong reason for refusing to, for standing by the original decision. Now, the dissent obviously takes issue on each and every one of those positions, and we can sort of talk through the dissent and the other opinion as well, if you'd like. I'll pause there just to
Yeah, sure. So talking more about substantive due process, the majority, like you said, points out that the weakness of the legal reasoning in Roe, and says the Dobbs opinion is exclusive to abortion and the state's interest in protecting potential life, and fundamentally different from the other cases, Lawrence, Griswold, Obergefell. But if we go look at Justice Thomas's concurrence, he's not shy in saying his opinion that substantive due process is not legitimate at all, and blatantly states that we should reconsider all these cases, calling them demonstrably erroneous. Chief Justice Roberts concurred and said that he believed the court has gone too far in its reasoning, does not agree that we need to overrule Roe completely. So how do you think we will see this line of cases unfold in the future, including like the right to privacy? Will these other cases get challenged? Will the court say, no, Dobbs was just, for abortion, potential life? Obviously, you don't have a crystal ball, but it seems the door has been at least cracked open.
Absolutely. I've tried to lessen the frequency with which I say this. But one of the saws that my students eventually sort of beat out of me was Yogi Berra's famous quote: "Predictions are hard, especially about the future."
Yes.
Which is why I sort of decline trying to make them with any sort of rigor. But just to return to Chief Justice Roberts' opinion just for a moment, it is notable because he diverged from the majority,
yes.
the five justice majority, and he would have also disagreed with the dissenters because he would have taken kind of the initial invitation that Mississippi offered, which was to tweak the undue burden standard in a very, it's probably more than a tweak, but to revise it in a very significant way that would have allowed for some pre-viability abortions as long as in the court's judgment there was adequate time for a woman to make a decision about whether or not to continue a pregnancy. That was not a position that was joined in by any other justice, kind of an intermediate position to retain something of the Roe framework for at least some time while allowing for a much broader range of regulation and restriction. With regard to Justice Thomas's opinion, I think his views on substantive due process are kind of not a new revelation. He sort of had this position articulated for a very long time, stretching back at least 10 years, at least to the McDonald versus City of Chicago decision, where he authored opinions sort of spelling out some similar reservations about the concept of substantive due process in general. And here he is suggesting that all of the many more decisions, including Griswold, Obergefell, and Lawrence, should be, in an appropriate case, subject to revisitation. He does sort of caveat, holds out the possibility that at least some of those rights might be grounded instead in the 14th Amendment's Privileges or Immunities Clause, which in his view is a much more proper home for this kind of rights protective jurisprudence. But given his sort of votes in the Lawrence and Obergefell case, at least, I think it's fair to mark him as skeptical of the overall reasoning of those original decisions, regardless of which clause is placed directly at issue. I think it is worth noting that both the majority and Justice Kavanaugh, who joins the majority but writes separately, just to express some of his own views, take very significant pains to emphasize that they are not saying anything in this opinion directly about those other fundamental rights cases like Griswold, Lawrence, and Obergefell. So if you're sort of looking at it as a pure kind of legal realist perspective, you're just trying to predict what the at least five justices on this court are going to do, I think there is substantial reason to doubt that there is a current majority on the court that is at least eager to go back and overrule those decisions. Now, I think the majority's opinion also functions as an instruction to lower courts to not kind of overread this decision, to sort of invite those challenges to these other fundamental rights decisions. It says this is about abortion and nothing else. We're not saying anything about the status of any of our other decisions, so those are going to remain binding on the lower courts as a matter of vertical stare decisis. Now, many people have pointed out, and I think with some fairness, that this does create some inconsistency in the doctrine. I think the Dobbs majority says very clearly the appropriate way, the only appropriate way to identify these fundamental rights that should be singled out for heightened protection is to look to what is deeply rooted in history and tradition. And applying that test, it's going to be very hard to identify something like the holding of Lawrence or the holding of Obergefell as worthy of the same kind of treatment as some other rights the court finds more preferable. So there is a doctrinal inconsistency there, but there are many doctrinal inconsistencies in constitutional law, and many of which persist for years and even decades. So I wouldn't draw too much inference from the fact that inconsistency exists in terms of the eagerness or willingness of a majority of the court to go back and kind of clean up and fix that inconsistency.
So, Professor Williams, the Dobbs opinion on its first page says that the authority to regulate abortion is returned to the people and their elected representatives. So, in other words, states, state legislatures can decide the policy on abortion for their state. And obviously, it's not news to anyone that people in different parts of the country and in different states have very varying and polarizing views on abortion. A Pew Research poll found that almost 60% of adults in Mississippi, where Dobbs originated, believe abortion should be illegal in most cases, while the same Pew Research poll found 3/4, about 74% of adults in Massachusetts believe that abortion should be legal in most or all circumstances. So you can see some of the polarization that exists there. Can you speak to the various reactions state legislatures across the country are having to this decision, and how does one balance the different opinions, beliefs, and what have you towards the issue of abortion that people have in some states versus other states, balance against the argument towards a fundamental right, a national right towards abortion?
Yeah, so one thing to be aware of is whatever happens in the legislatures from the point of the Dobbs decision on is going to be informed by what has come before, and by which I mean that there are some states in which it's not even necessary for the legislature to take any vote to re-implement some restrictions of the type that would have been invalid under Roe. And this is not just about Mississippi, where which had the 15-week abortion ban that was challenged in the actual case. Many other states had similar laws on the books that had been enjoined by federal courts. Several states had what are called trigger laws in place, essentially saying if and when the Supreme Court overrules the Roe decision and returns this authority to the states, we will ban abortion or restrict access to abortion. In some cases, that would happen automatically. In other cases, that would happen on some kind of certification process. But that process is underway as well. Now, a couple of just sort of observations about the internal politics surrounding all of this. First observation is whatever the state legislatures might prefer to do is going to be constrained by whatever is in the state constitutions. Many states have their own constitutional provisions that have language similar to the Due Process Clause of the federal constitution, or other provisions that have, in at least some states, been interpreted to confer rights similar to the rights recognized in Roe. The Kansas Supreme Court, for example, just a couple years back, handed down a decision that recognized a right to abortion under the Kansas Constitution. Now, Kansas is a fairly conservative state. If that were simply a matter for the legislature, that would be something that they could put into place tomorrow. But until that decision is overruled or changed by a constitutional amendment, which there is an amendment on the ballot, I believe, that's going to be voted on this summer, restoring that authority to the legislature, those going to be restricted. So that's going to be one barrier to any sort of legislative policymaking. A reminder that kind of state constitutional law is also a thing, and also a very important constraint on legislative decision-making. The other observation, just sort of in terms of internal politics within a state, is that I think for the first time in a very long time, this issue is now real. It's genuine. It's live. This is not a matter where legislators can just posture in the way they could during the Roe era, enact these bans in the expectation that they will be struck down by the courts and never go into legal effect. Now it's actually going to matter what they decide, and voters are going to have to appraise the actual consequences of those decisions. In some states, we will likely see very strong support for those measures. In others, we will obviously see more opposition, but I don't think we should necessarily assume that any of that opinion is going to be static. The opinion can change over time as the facts on the ground change. Now, the other big issue that this decision is going to tee up is going to be the relation among the states in terms of the interstate movement of individuals seeking access to abortion, which is going to be a new source of legal friction among the states, particularly to the extent particular jurisdictions try to regulate or restrict or punish their domiciliaries when they move beyond state lines and try to procure access to abortion in another state. And that is an issue that is going to be most likely confronting the courts and something the Supreme Court may have to decide in the somewhat near future, sort of. So there's a lot to work out what happens in the kind of post-Dobbs environment.
You just jump in to follow up on that. That's obviously been something that, as you pointed out there, that folks are really talking about. How will that work when you have sort of one state against another state, and what are states sort of able to do to enforce their policies, and what happens between states? Could you just, to the extent you're able, give us a little bit of a preview of some of the legal issues, constitutional issues that can come up when you have that conversation?
Sure, and this gets into another area that I teach in and think about, which is conflicts of law. And this has been kind of a more-abound area for very interesting to some of us, but it was a major issue surrounding the law of gay marriage. It kind of dropped out of constitutional significance, but now it is kind of returning with a vengeance, which involves the how courts should go about sorting out which jurisdiction's law, when particular facts or circumstances implicate the law of more than one state. And there are various provisions in the Constitution that speak to this question, including the full faith and credit clause of Article 4, requiring each state to give effect to the public acts, records, and proceedings of other states. The Article 4 Privileges and Immunities Clause, which prohibits discrimination against out-of-state citizens. The Privileges or Immunities Clause of the 14th Amendment, very similarly phrased, was been interpreted to protect to some degree the right of individuals to travel among the states. And finally, the dormant aspects of the Commerce Clause, which limit the ability of states to restrict or discriminate against commerce from outside the state. There's also some substantive due process in here as well, which is because the right to travel has also been protected as a matter of 14th Amendment substantive due process. And in fact, Justice Kavanaugh, in his concurring opinion, tries to kind of preempt some of this debate with a sentence that just sort of says that he thinks that the right to travel is of such a source that will restrict states from trying to punish their residents when they try to travel outside the state. Now, that is probably going to be, at least in the early going, the most significant kind of source of cross-border friction. Individuals, a pregnant woman who is gets pregnant and is domiciliary of a state that has stringent abortion restrictions, trying to travel to a jurisdiction that has more lenient abortion laws or no abortion restrictions whatsoever. It will come to the fore most pointedly if, in fact, a jurisdiction tries to limit that freedom. Say, have a statute saying anyone who assists in abortion or anyone who tries to procure an abortion will be subject to criminal penalties or civil penalties. State of Texas, for example, has enacted a civil penalty enforceable by any person for anyone who assists or in trying to procure an abortion. If that's construed to have extraterritorial effect, you could see lawsuits against an abortion clinic in, say, Massachusetts, if a Texas domiciliary tries to take advantage of abortion services there. So there's a lot of questions that are going to need to be worked out by the courts about kind of how this works and what are the limits of a particular state to reach conduct in another state. Now, the Supreme Court has been sort of very lenient on this front to date in terms of constitutional limits on choice of law and conflicts of law, but this might be an occasion for much more kind of stringent restrictions on that kind of extraterritorial authority.
Great. So thank you so much. And coming back to stare decisis, it's looked at as something that promotes the legitimacy of the court. And overruling Roe and Casey is going obviously against stare decisis. And so how do you think this affects the legitimacy of the court, or how the public, views the court in general?
Yeah, so stare decisis is a sort of complicated subject, as
Yes.
I'm sure anyone who studied constitutional law has kind of learned, because it is an important principle for the court, and one they frequently intone and frequently insist upon as an important kind of criterion of the lawfulness of their decision. At the same time, it is a doctrine that no one believes should be absolutely permanently controlling in all circumstances. Every justice is in favor of overruling at least some cases in some circumstances, and very supportive of past instances of overruling. Some of the most widely praised decisions in the court's history, Brown versus Board of Education, for example, have involved overruling prior precedent. So it's kind of hard to figure out the impact of a particular decision. Now, this particular instance is not an ordinary overruling. I think the high public salience of Roe, the fact that it's been challenged before, the fact that the Supreme Court has upheld it before on stare decisis grounds makes it meaningfully different from a lot of the prior instances that one might point to as examples of overruling. And I think if we're thinking of sort of legitimacy in terms of public perception or kind of sociological legitimacy, I think a lot of that at any given moment in time tends to track how people feel about the underlying merits more than sort of the abstract questions about constitutional theory or legal process. So people who are strongly against abortion are likely to be very happy with this decision. Those who are strongly pro-choice are likely to think this is totally illegitimate and totally contrary to the proper role of the court. I think we are in interesting times, just given the current composition of the court, the current kind of alignment of the justices, and the fact that for the first time in quite a while, the partisan division, the ideological division on the court matches fairly well the partisan division of the appointing presidents. All of the Republican appointees share a broadly similar philosophy that is meaningfully different in important ways from the types of philosophies that unite the Democratic appointees. Now, that has significance for, I think, how the court is going to be perceived. I think if one side is consistently winning, you're going to see the other side very skeptical of the legitimacy of the court for some sustained period of time. Now, of course, it would be the exact same process if the roles were reversed, if this were a cohesive majority that shared the ideological leanings of the Democratic appointees. I think you would see similar frustrations and similar levels of disapproval on the right. So I think it is part of a broader pattern of degradation or erosion of public support and public confidence in institutions more generally. And I would expect we are seeing some of that now with regard to the court. And I think we will, again, predictions are hard, but I would in no way be surprised if that erosion sort of continues or levels off at some meaningful way, meaningfully lower than it has been in our recent history.
So, Professor, and again, we appreciate your time and thank you for joining us. Just our final question, just following up on what you just said.
I have another question.
Oh, okay. Sorry, our penultimate question.
Yeah.
So going off your point there, so, there was, I'm not sure if you follow the Onion, but it's a satire website. In the wake of this decision, they on their website sort of put all these headlines out there that said you're nodding, so I assume you saw this. They said Supreme Court decides.
I saw the collection. I saw the front page.
Right, it was basically Supreme Court decides 6-3, and then just a million different things. And so there's this idea out there that the Supreme Court is just
teamed up issue. Yes.
Right. The Supreme Court is just irreconcilably polarized, and you're just going to have this dominant conservative wing, this six that's always going to beat three, and you have people talking about packing the court and all of these things. To the extent you're able to sort of discuss and have some insight on this, does the court in your opinion, in and of itself have an awareness of some of this? Do you think that this, and obviously Dobbs is a case that is far more polarizing than maybe sort of the more of the mundane issues that the Supreme Court also decides that we don't really spend much time talking about. Within the court, is there a recognition for, where the institution is headed and public perception of it? And is the court, in its own awareness of itself, able to find some balance here at a time where it feels like there is not very much of it?
So I think there is a cognizance on the court, and I think this is very clearly sort of something that we can discern very clearly reflected in Chief Justice Roberts's opinion and preferred disposition of this case. I think he shares some of the concerns. This is somewhat speculative, but I think it's a fair reading of the opinion and the surrounding circumstances. It seems that he is concerned about going too far, too fast, and wanting to ensure that there, both as a practical matter, there's not too much disruption attended by the court's rulings, but also concerns about the broader perceptions of the court and its overall institutional legitimacy. Now there is a countervailing trend, obviously, which is kind of why no other justice joined his opinion, and it's always this tension. It's a tension played up by stare decisis. If you think the law is wrong in some important way, do you stand by that simply because the decision has been rendered in a particular way in the past, or do you try to correct it? And if you try to correct it, do you try to do so as quickly as possible, particularly if you know that the composition of the court might change and the cohesive majority you now have might be a time-limited phenomenon, or do you take a more cautious approach to try to preserve some of the institutional capital that might be attendant there too? And it is a question the court is now kind of navigating and sort of trying to balance. And I think the discussions of court packing, I don't think will abate anytime soon, whether there's policy movement on that front or not, at least until the court sort of takes its foot off the throttle a little bit and either proceeds in a more gradualist fashion or decides to take some more lower profile cases for the bulk of its docket.
Awesome. Well, first I wanted to plug your Twitter, talking about internet satire. It's really great. I recommend to everyone.
So Professor Williams' Twitter is internet satire.
Of course. He's got a great Twitter feed.
So thank you very much. I share all my substantive thoughts for other venues because Twitter is not for substance.
No.
No.
All right. And my last question is actually today, we're recording this July 8th.
That's the day.
So the White House just announced that Biden is going to issue an executive order surrounding Dobbs' case and the fundamental right to abortion. Wanted to know how this could affect things. I don't think the order is actually out right now. I think the White House just announced he was going to give one.
Thank you. This is breaking news to me.
Yeah, it was
breaking
right
news
before,
on Just Law now.
Right before I said, "Oh my gosh, we have to ask him about this."
This is great.
Yes.
Sorry, I haven't had a chance.
No, that's fine. I just how would an executive order?
Again, I think there are things the federal government can do. A major issue is going to be the treatment of medication abortion.
Yes.
Which is increasingly prominent in a way that it was not at the time Roe was handed down, and because that is regulated by the Food and Drug Administration at the federal level. There are going to be questions about federal preemption. If a state tries to block or penalize the use of that medication, there might be questions about whether that is consistent with federal law. There might be questions about access to abortion for federal employees and different policies. There are things the federal government can do, certainly, to influence this decision. And the ultimate question, and one that is going to be out there as well as part of our politics, is are we going to have national regulation of abortion of some kind? Just because it is not in the majority of the Supreme Court's view, a constitutional right, does not mean that it might not be something that Congress, pursuant to its commerce power or some other enumerated power, might try to or choose to regulate. And if that step is taken either could go either way as well, either a recodification of Roe of some kind or a abortion ban, as some have proposed at the national level, or abortion restrictions at the national level. If either of those measures is taken at some point in the future, there will be some questions about the scope of Congress's authority as well.
Very good. Professor, I was speaking with Professor Ryan Williams about the Dobbs opinion from the Supreme Court and the issue of abortion, all the important constitutional discussions that flow from there. So again, I'm Tom Blakely. I'm here with Samantha Beyar, and we were lucky enough to be joined by Professor Williams of BC Law here on the Just Law podcast. And until next time, that'll do it. Thank you for watching, and we'll catch you again soon.